What else?
One last issue, and that's the court has included, as it relates to, I think it's count 3, Mr. McGinnis. Count 2? Count 2, I'm sorry, 820. Jury instruction 820 is mentioned in there. So I guess the language in there that I'm having, maybe it's just me, difficulty kind of coming to some type of congruence with is the first full paragraph, the last sentence says the defendant does not have a privilege of self-defense as to Richie McGinnis. I don't know if you see that. However, later on in the instruction, it says if the defendant was acting in lawful self-defense, his conduct does not create an unreasonable risk to another. So I guess the concern I have is one portion says he doesn't have a privilege of self-defense. Then another portion of that same instruction says he does have the privilege.
I stumbled over the same language.
Yeah.
And what I ultimately decided was intended, and I think I might add correctly, intended by the instructions committee, was that he does not have a privilege of self-defense as to the third person, but the fact that he was, if he was, in exercise of his privilege of self-defense is a factor for the jury to consider in determining whether his conduct was criminally reckless, and also was a factor for them to consider in determining whether it was done with utter disregard for human life. That's how I read it. I certainly don't think I would want to get... you could put a law school test together on this, But that's how I read it. Now tell me where you think I'm in error.
Well, I'm not saying you're in error. I'm saying that I think if he's in self-defense as it relates to Mr. Rosenbaum, according to 820, he then has a perfect self-defense. If the defendant was acting in self-defense, his conduct did not create an unreasonable risk to another. So...
Well, wait a minute. Let's give a situation where I'm out on the street and somebody confronts me, and there's a family of 4 little children right behind him, and the other actor, puts me in, I'm in fear of death from the assault by this individual. So I whip out a gun and I open fire, and I include in the zone. The danger zone is not only the actor with whom I have a perfect privilege of self-defense, but also the 4 children who are behind him. And I think this is how I reconciled that reading in my mind, was that when the jury decides about the charges involving the 4 children, the jury is to consider whether I was acting in self-defense with respect to the bad actor. That's a consideration in determining whether my conduct was reckless with respect to those children, and also whether it was showed utter disregard for human life. And the jury might reconcile that by saying, well, you should have tried to change positions so that your shot wouldn't have the children in the background. That's how I reconciled it. But I agree with you. It's confusing.
Because I read 820 to say that if the bad actor in your situation, if you were acting in self-defense, the instruction says that you did not then create an unreasonable risk to another. It's what it says. So I don't think then...
Well, why did they... I'm sorry, go ahead.
No, so I guess what I'm saying is I don't think if it's self-defense on the bad actor in your scenario, then by that fact, according to 820, the instruction says your conduct did not create an unreasonable risk to another. So if we're talking about the children behind that bad actor, the statute says, or the instruction says, then if it's self-defense, it did not create an unreasonable risk. And then there's a period. So...
well, why does it say up above that in the second sentence, the fact that the law may allow the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful.
I agree. That's what I said to you.
No, what you're telling me is that the fact that the law may allow the defendant, the fact that the law may allow Schrader to use force in self-defense as to the bad actor does not necessarily mean that recklessly endangering the safety of the children was lawful. Why isn't, you're telling me there's an absolute privilege of self-defense, not only as to the bad actor, but also as to the children.
Only if, according to 820, only if the conduct against the bad actor was self-defense. That's the part I've read to the court. If the defendant was acting in lawful self-defense, his or her conduct did not create an unreasonable risk to another. Period.
If you look at the comments from the instructions committee, on page, well, I don't know if you've got the pages there, but well, I have them, but near the end it says, for example, assume that a defendant is charged with causing reckless injury to the victim and raises the defense that he was acting in self-defense against someone else and thereby injured the victim. Criminal recklessness requires that the defendant's conduct created, quote, an unreasonable and substantial risk of death or great bodily harm, unquote. In considering whether the risk was unreasonable, the jury should consider the evidence that the defendant was acting in self-defense. So that's what I'm thinking is that what they mean is there is not what you're arguing, I think, becomes a perfect self-defense as to injury to others during the exercise of perfect self-defense, and I don't think that's the law. It maybe was what we once thought, but I don't think it's the law now, and that the jury, when they approach the McGinnis case, looks at whether the defendant, even if exercising perfect self-defense with respect to Mr. Rosenbaum, that he doesn't have a self-defense as to Mr. McGinnis's endangerment, but instead the jury is told you consider, because, and I'm interrupting myself, because one of the things we tell the jury, and you've referred to it several times right here in our discussions in the last couple of weeks, one of the things the jury considered is what the defendant was doing, why he was doing it, how dangerous was the conduct. When they weigh those things with respect to the count involving Mr. McGinnis, they consider, if they decide that it was perfect defense, self-defense as to Mr. Rosenbaum, then they consider that in deciding what the defendant was doing, why he was doing it, how dangerous was the conduct, and then they make their determination whether the fact that Mr. Rittenhouse was, if they find that he was acting in self-defense, they can weigh that in deciding whether or not he recklessly endangered the safety of Mr. McGinnis. That's how I read it, and that's how I'm going to say it. But I'm going to try to skirt around those 5th, 6th, and 7th counts because we don't have an instruction for number 7 and number 6 is. I've had lots of statutory issues come up over the years, and this is the naughtiest. Okay. Other than that, any problem with the instructions?
Nothing. Nothing else from me, Jim.
State?
No.
Okay. Let's get the jury down.
Your Honor, before you do that, Your Honor, I do want to put something on the record with regard to the jury.
Oh yeah, I got something here too. Yeah, what's up?
Your Honor, at the end of the proceedings last night, Brian Stute from our office came in to begin the process of setting up the audiovisual equipment and whatnot. While he was, I think, entering the courtroom from the hallway, he passed by one of our jurors, and I'm going to identify this juror as juror 52. I can say more about that person's identity, but I don't want to do it openly in court. My understanding is that juror 52 recognized Mr. Stute, said something like, hey, how you doing? Like they knew each other, and I think Mr. Stute responded, politely in response, and that was the extent of their interaction. Mr. Stute has explained subsequently that he had a previous employment where he remembers juror 52 from, and so that's the extent of their prior knowledge of one another. So I wanted to lay that on the record so that everybody is aware of that. I did tell counsel about that.